Hi, everybody. Welcome to the ABA Legal and Compliance Series. Today's conversation is about stark anti-kickback and False Claim Act exposures. ABA providers don't actually set out to create this legal risk. The exposure usually builds slowly through referral relationships, incentive structures, supervision models, documentation habits, and growth pressure. And by the time a payer order or government letter arrives, the real issue has often been developing for months or years. To help us think clearly about this, we're honored to be joined by Glenn Prives, shareholder at Baker Donelson, who works directly on healthcare enforcement and investigation. We're going to focus on how these cases actually start, what regulators look for, and what defensible ABA operations look like in practice. Glenn, thanks for being here.
Thank you, Tzvi. I'm very happy to be there. Appreciate the invitation to speak.
Thank you. Let's do an enforcement reality check. How much enforcement attention is ABA therapy getting today compared to a few years ago?
So thankfully, it's still only up a tick compared to a few years ago because ABA therapy is very new under the law. The laws are much more clear about problematic situations when you're talking about earlier forms of behavioral health, particularly involving psychiatrists and psychologists. But when you get to ABA therapy itself, it's still a new area of regulation. That being said, as the government continues to prioritize healthcare fraud overall, and that's both the federal government and state governments, it is going to get more attention, particularly, as many people in this episode know better than me, the increasing delivery of ABA therapy services. The more you use it, the more chance of fraud.
Right. Is an ABA clinic being investigated more often now? And what's driving that shift? Are the regulations changing? Are they tightening the noose in terms of regulation? Or is it just that you feel there's a trend, an uptick in enforcement?
It's more of an uptick in enforcement overall. Again, when utilization of any type of healthcare service increases and there's reimbursement, particularly coming from the government, and the government pays attention. They want to know where the dollars are going. And it's just a reality that I think diagnoses are appropriately up because people are more recognizing the signs that require treatment of ABA therapy. The regulations are starting to increase a little bit on a very limited state-by-state basis, but that does impact state Medicaid, since Medicaid, obviously, as everybody on this call knows, is a hybrid federal and state program. And so there are more ways to trip up than there used to be.
Do you see a difference between provider size, whether it's a small clinic, fast-growing groups, or PE-backed platforms?
I don't, actually. I'll say it this way, which is very, very small provider groups, whoever backs them or doesn't back them, tend to not get as much attention simply because they're not getting as much of the pot, so to speak. So their utilization numbers just overall are going to be lower because they're just not large. Being private equity backed doesn't usually raise the enforcement risk at the end of the day, especially because, first of all, many private equity transactions are actually private. And even for those that are, that's not an automatic flag for the government when it comes to False Claims Act enforcement.
Right. You would think that the PE-backed platforms probably runs more smoothly and they're better operators versus the small guys. But as you say, it's a trade-off between how much time are we chasing a few dollars.
I don't know that PE-backed platforms technically run more smoothly. So sometimes that's true, and I can tell you sometimes that is not. And even when they do a little bit, it's more about tightening the non-clinical aspects of the operation versus the clinical. And I always look at delivery of care, utilization, treatment options as clinical as opposed to non-clinical. Private equity might be better at making sure the bills get out more timely and the claims get out more timely and collected. But I don't see their involvement as raising risks in this scenario that we're talking about.
And just further to that point, do you see PE-backed platforms, do you see the corporate guys pressuring? I mean, we'll get to that more later, but are they putting pressure on the small clinics to produce, or are they totally leaving the clinical up to them?
The lawyerly but true answer is it depends. So when you have a PE acquisition, and certainly that's a very important topic here because behavioral health overall is a very hot area of interest for private equity. They see a lot of growth there. They also see a lot of small providers right now, very, very fragmented market. So that's when private equity usually swoops in because they can consolidate and gain more heft and all the benefits that that brings. They look at the clinical delivery of services, and if there's more capacity to be wrung out of the system, meaning in this realm, if there are certain individual providers who are not busy and could stand to be more busy, I do think there's a push to make sure that you're marketing and getting more patients, that those providers are profitable in terms of not being overpaid or being paid to not do very much. But that's the limit of the pressure. I don't see private equity getting involved in diagnoses or actual necessity or utilization. I don't think they have the background to do that. And I think most of them are self-aware enough to realize that.
Getting into how investigations start. When ABA clinics get into serious trouble, what usually triggers the initial review? Is it a whistleblower? Is it data analysis? Is it now AI starting to uncover all these things?
So it's all of the above, but let's unpack that a little bit for a second. So one of the number one reasons is an uptick in utilization. That doesn't mean automatically the provider is not delivering unnecessary services or that utilization is improper. It's just if there is a provider who has a major uptick from where they were before, or if there is a provider that's showing to be an outlier based on utilization, that usually sends up a flag to do some level of auditing, even if everything is 100% okay. There's no real way to avoid that risk other than not doing business.
Well, it only becomes a risk if you're not running it properly, right? If everything's
correct.
documented.
That's a fair clarification point. But if you're running it properly, you're just going to run that risk anyway. The second point is whistleblowers. Let's take that for a second. So whistleblowers are a real risk, and there are whistleblowers who properly make claims, and there are whistleblowers who improperly make claims. That being said, on the front end, we always say to clients, you should run a very tight ship. You can't necessarily prevent someone from making some claim to the government, how unfounded as it is, but certainly you can reduce that risk if you are running a tight ship. That being said, when a whistleblower makes a claim to the government, you don't always necessarily find out about it. And even if you do later find out about it because the complaint was actually filed and it's unsealed, the government does not choose to intervene in every single whistleblower complaint. They make decisions based upon what they deem to be the merits of the complaint and use of resources. Now, when a complaint is filed by a whistleblower and then unsealed, if the government doesn't intervene, that doesn't mean the complaint made by the whistleblower goes away. It does mean the provider would still need to deal with it if the whistleblower chooses to move forward. Now, when the government doesn't intervene, though, it certainly weakens the whistleblower's claim, and a number of times those claims and complaints will die. Now, whistleblowers, most often they're going to be disgruntled employees. Sometimes they're patients. Sometimes, in rare circumstances, they are other providers. It does happen. It's relatively rare, only because if you're a provider, particularly a competitor of the provider you're whistleblowing on, you want to make sure your house is 100% in order if you're going to file a whistleblower complaint on another provider. And I would say that despite with the best of intentions and the best efforts, given the morass of regulations in this space, given how they're ever changing, given how they're very vague, it's almost impossible to be 100% compliant.
So we talked about whistleblowers and we talked about utilization rates. What about things, poor operations? Where would you see weak operations that often get into trouble with this?
Weak operations are usually going to result in poor compliance practices, but there really isn't another way that those are going to get flagged other than whistleblowing, some sort of other meritorious tip, or utilization issues. In other words, you might run a poorly operated practice that has compliance issues. How is the government going to figure that out? The government really isn't sending around inspectors willy-nilly to ABA practices or other healthcare providers just to see what they can find. They don't have the resources to do that because there's enough actual fraud that they have to focus on going on. The only time that's usually going to come into play again is if your poor operations lead to a whistleblower or some other tip to the government. There's usually always a tip. They don't have enough resources otherwise.
What about a claim that comes from a payer who's demanding recoupment and is not happy with the way the billing is working?
So payer claims, and we're talking not Medicaid here. I'm going to separate Medicaid from the pile here. We're talking about commercial payers. They will do their own audits. They run their own investigations. On occasion, if they believe there's true actual fraud, and I mean not limited improper upcoding, not mistakes. We're talking actual very high threshold. In those instances, they may refer it to the government as well. But you have to be doing, at least in the payer's mind, some seriously bad things to end up in that route. You'll still have to deal with the payer, and folks are probably used to commercial payers doing audits, usually tipped off on utilization issues there, trying to claw back money and ending up in battles. And unfortunately, the payers are the 2,000-pound gorillas in the room. Providers typically are not. Fighting those are very difficult battles that myself and my colleagues deal with on an everyday basis. They're not always right, though. Payers are not always right, and payers can be beat.
Let's talk a little bit about anti-kickback. Where do ABA clinics unintentionally create kickback risk when trying to grow?
Okay, so let's take 1 minute on the anti-kickback statute itself, and let's further acknowledge we're talking about, for the specific minute here, the federal anti-kickback statute. So number one, the reason why the federal anti-kickback statute is of significance here is if you've got Medicaid dollars, we're not really seeing Medicare in this space, obviously, but if you've got Medicaid dollars, if you are engaging in potential fraud, that will implicate the federal anti-kickback statute. Now, what does that really mean at the end of the day? Number one is you actually don't need to be a provider to be implicated with the anti-kickback statute. If you're a non-clinical person and you're working with a provider in a way that would implicate the anti-kickback statute, the provider is at risk and you, the non-clinical person, are also at risk. You can violate the anti-kickback statute as a non-clinical person. Really, the essence of it is you can't pay kickbacks for referrals. And note also that if a kickback is being paid, it's not just the giver that is at risk, it's the receiver as well. The law applies to both the givers and the receivers. I think sometimes people think that if they're merely recipients that they don't have any exposure. That's not true. At the end of the day, the anti-kickback statute is both a civil and a criminal statute. So some claims that are filed, some lawsuits are filed, are limited to civil exposure, money, and some do trend into the criminal realm. Not every case does. Typically, the more egregious cases are going to be in the criminal realm. Who enforces the federal anti-kickback statute? The federal government. So we're really talking about the Department of Justice. We're talking about U.S. attorneys' offices in the jurisdiction where your operations are. Where does it come into play? Tzvi, you were kind of heading that direction, which
Absolutely.
is essentially when clinics are trying to grow, they tend to get very entrepreneurial. The unfortunate thing in this space, it's in healthcare overall, is strategies that make business sense and that are workable in other industries don't always work here. Marketing itself is generally fine. But if you're going, let's say you're an ABA provider and you want to take space in a clinician's office who happens to be a referral source, but perhaps that it's a good location because that clinician's practice doesn't offer ABA services, but is looking for help, given that person's patients. If that person is a referral source, then at the end of the day, that doesn't mean you can't take that space, but you are going to implicate the anti-kickback statute. And so you have to look, okay, is there a safe harbor that I can properly structure my arrangement under? Rental of space has a specific safe harbor. Typically what that's going to mean is you've got to pay them fair market value rent. You only utilize the space that you absolutely have a true need for. You're not taking on more space than you need as a way to get more dollars there. You only use the space when you actually need it. You need a written contract. The contract has to be signed by both parties. That's an example. I will tell you that one of the things the government does usually pay attention to are improper rental arrangements, because sometimes what people do is they take more space than they need. They use it more. They secure it for more time than they need. That means they're paying extra rent. It's above fair market value at that point. That's a kickback to a referral source at the end of the day. Now, importantly, and I apologize to all for the monologue, but I just want to get these points out to complete the thoughts for everyone here.
That's what we're here for.
Well, lawyers can drone on, and some of us, myself included, are self-aware of that. The anti-kickback statute is what I would call a pseudo intent-based statute. What does that mean? That means that with the arrangement you're entering into, for it to violate the anti-kickback statute, you must have had in mind one purpose: to actually, secure referrals, to pay for referrals, to violate the anti-kickback statute. What that further means is if you're creating an arrangement that may implicate the anti-kickback statute, but you don't fit it squarely within a safe harbor, that doesn't mean your arrangement is per se illegal. This is not what we call a strict liability statute. It simply means that if it's not squarely within a safe harbor, it may be illegal or it may not. It depends on facts and circumstances at the end of the day, and your risk tends to be a little bit higher. But I would be lying to everybody on this call or whoever's listening to this if every single arrangement squarely fit within a safe harbor. First of all, the government has said you don't need to do that. What's the advantage of being in a safe harbor? Well, if you're in a safe harbor, and being with it, by the way, means if the safe harbor has 6 prongs, that you meet all 6 prongs, then usually you are going to be completely safe. Now, somebody posed the question, is the anti-kickback statute only for Medicaid? So the answer is the anti-kickback statute is only for federal government money. If you take federal government money, the anti-kickback statute applies. If you don't take federal government money, the federal anti-kickback statute does not apply. But before you hang up and decide you're done listening to this, many states have their own version of the anti-kickback statute. This is going to vary by state, but some states it would apply even if you take commercial pay or private pay. Even, this is going to depend on the state. So if you think you're not taking federal government money and you're in the clear, you might be in the clear with the federal anti-kickback statute. Doesn't mean you're in the clear with a state version of it. Because the states are very different about that, at the end of the day, that's what's going to apply. Now, somebody just asked a very good question, which I also, because I'm seeing some of the chats go through into me. I don't know if I'm supposed to be reading them, but I'm watching some of
That's
them.
great. No, I leave it to your discretion what to
I'm
answer.
gonna do my best when it comes to this. So somebody asked about New Jersey as an example. So New Jersey is actually a great example. So the answer is it's going to depend. So New Jersey does have a what I'll call a anti-kickback regulation under the physician rules. So where that would come into play for an ABA therapy provider is if you're paying kickbacks or potentially, let's call it potentially paying kickbacks to a physician for referrals to you for ABA services, yes, in New Jersey, that would actually implicate the physician rules because you're paying the kickback to a physician. That physician is governed by those rules. The other thing that New Jersey has, as an example, is it's always an interesting name, but it's basically a coercion statute, which is if you're in a position of fiduciary trust to a potential patient, and you are and a physician usually is in that spot. ABA provider, it's less so, it's gray, but you're paying somebody for referrals or you're incentivized to steer somebody a certain way. If you're incentivized and you don't necessarily disclose that incentive to the person you're referring, that can also create risk. That particular statute has not been enforced very much. It's written very vaguely, and we have very little guidance on it. But my rule of thumb, generally, and I admit that business folks sometimes look askance at me, which is even if wherever you are located, the anti-kickback rule in that jurisdiction doesn't explicitly apply to you, it's a good guidepost to follow. Because if you're going over that line one way or another, somebody's going to find trouble at that point.
How about school-based ABAs? What's the risk over there? And
well, so it depends. So school-based ABA can mean two different things to me. So let's clarify. Are we referring to situations when the school is paying the ABA provider for all services, so nothing's getting billed to insurance, or there's just an arrangement whereby the school happens to send it to XYZ ABA provider, but the ABA provider is still billing the relevant students or families' insurance?
I would assume that the second case is the one that invokes trouble.
Yes. So you're going to have, depending upon the state you're in, you're going to have the same rules apply in your state if you're billing Medicaid or if you're billing commercial insurance or private pay. Nothing changes there. I tend to think that relationships with schools get a little bit more scrutiny just given the fact that schools are usually not-for-profit. It's publicly owned for one type of public schools, but even private schools are not-for-profit. They're subject to other rules as well, given their tax-exempt status, and those can be tricky situations. But look, there are perfectly good ways of marketing services, interacting with different folks. It's really about, when you're actually giving remunerative incentives that you start to walk into certain tough lines. But it's very fact and circumstances based. Certainly giving somebody a bag of money is going to be a problem. And before everybody laughs too hard, that actually does happen. Those are true facts that people are foolish enough to do that.
For that, we don't need a podcast. We're trying to figure out the intricacies of doing the school a favor or certain things that you do for the school based on this relationship, which seems innocent, yet it can trigger anti-kickback.
It's difficult because it's very fact and circumstances based. I think if you're doing educational programs for the schools, I think that that's appropriate. I think that if you're tabling at school health fairs, that is appropriate as well. Even if you're tabling at a school fair and you have to pay a nominal fee to do that, let's say you have a school health fair. Okay, you get a mix of different providers and also non-providers who are usually going at tables or exhibits at that fair. Okay, if the school charges a fee to each provider to basically cover the cost to the school, not the profit, but the cost of the school of holding the fair. So long as everybody's being charged the same appropriate fee, that's absolutely fine. But if the school is charging fees that would result in some sort of profit for the school and you're paying it, or if certain exhibitors pay the fees and not others, namely the ones who are in the position to receive referrals from the school, that's going to be a problem as well. But it's not that you can't have no relationship with a school. I wouldn't be providing free care for any students of the school. I think that that's a very dangerous prospect, but other marketing outreach is generally appropriate. Free consults is not something I would be doing. Free consults are typically going to run afoul, because that's usually going to take it for that's usually a concept of what's called beneficiary inducement. Okay, so the concept of beneficiary inducement is, okay, we've talked about kickbacks when you're trying to generate referrals from referral sources. The other part of the vein is you can't do something that would run afoul of inducing a beneficiary to choose you. If you offer someone a free consult, particularly when it's a service that would otherwise be covered by insurance, you're going to run into trouble at that point. One question that's coming: can you pay your employees who are doing outreach to providers, doctors, for referrals that come through their work? So that's a very, very good question that is starting to raise further flags, and kind of the law is a little bit in flux. It was typically expected that if you employed someone, and I mean employee versus independent contractor, I will come back to that in a second. If you employed someone and you paid them a bonus tied to referrals, under the federal anti-kickback statute, that was okay, because there is something called the bona fide employee safe harbor. And if that person is truly an employee, you can almost always pay them anything you want, including based on referrals. I will tell you, before everybody gets too excited there, that there is some recent case law, and I mean recent, that has somewhat thrown that concept into flux. I would say that people probably, simply based on that case law, are not likely to change that practice right now, because that was a pretty well understood rule for a long time. But it's gotten a little gray. As opposed to, you cannot compensate an independent contractor or a 1099 based on referrals. That's a long understood rule. Why? There is no bona fide independent contractor safe harbor under the anti-kickback statute that allows that type of compensation. When you are compensating an independent contractor for work that they do for you, there is a different safe harbor where the compensation has to be fair market value and does not vary with the volume or value of referrals. So let's distinguish very clearly there, W-2 versus 1099 on that issue right there.
How about BCBA's compensation structure?
So I'll ask you the question. Are we talking about a BCBA who is going to be an employee or an independent contractor?
So I understand that most BCBAs legally have to be employees. Independent contractors are another whole episode. But
so let's break that down a little bit as to why. So we're gonna go on a slight 2-minute tangent, folks, and then I'm gonna bring us back. But I promise you the 2-minute tangent is relevant. Okay. So employees versus independent contractors overall, I don't think it's a secret to anybody here. Departments of labor on the state level do not love independent contractors, nor does the IRS. So keep that in mind. There is usually a control test, and if the, for lack of a better phrase, employer is exercising a certain amount of control based on the control test, that person needs to be classified as an employee and not an independent contractor. I will further go down that route by saying, and that's because you guys brought up private equity, that in private equity transactions overall, but particularly in healthcare, one of the hot button compliance issues they look at is whether or not a potential seller has been misclassifying employees as independent contractors. The more you swing towards independent contractors and take that risk, the more risk you're running with the Department of Labor, the more risk you're going to run for yourself if you're trying to sell your organization someday. I'm just telling you, it's a very big issue. That's just typical W-2 versus 1099. Coming back from tangent. For BCBAs, the concept is going to be quite similar as non-clinical marketing folks, and I'll explain why. When you compensate one of your providers based upon the work they're doing, it is in some ways, and again, I don't make the law, I don't make the rules, I may not agree with them, just telling you what it is akin to some extent as paying them for referrals as well. Even if they didn't refer the patient per se, their work is still seen as being a referral to the overall employer who is getting the reimbursement for the work. So the same rules that I talked about on the bona fide employee safe harbor, as opposed to the independent contractor thing, it's the same type of compensation model generally when you're trying to figure out how to compensate BCBAs. So listen, from both the employment lawyer that someone's going to be and the healthcare lawyer, you're always going to get a push towards making them a W-2. Make them a part-time employee if they're part-time. If they're truly part-time and the reason you've been avoiding making them an employee is benefits, it obviously depends upon, to some extent, the state and the benefit plans. But for the most part, if it's a true part-time employee, you don't owe them benefits. Yes, you have to pay the payroll tax. I get it. I understand it. But if your goal is to avoid the payroll tax, you may be creating so much enormous risk for yourself that dwarfs the amount of the payroll tax.
So we were talking about referrals with the BCBAs. What about productivity targets? Does that run a risk?
If they are employees and you want to set productivity targets and compensate them accordingly, that's typically going to be fine under employee safe harbors.
Really?
Yes, because the law doesn't say, excuse me, the law doesn't say that you can't incentivize a BCBA to be productive. However, you need to distinguish between making sure the BCBA understands that services need to be provided that are necessary. That's the nuance. It doesn't mean you can't say, hey, I'll pay you this much per hour of services rendered, or this much for this and this much for that, or you have to hit an average of this amount of patients. That's fine, so long as the services that they're delivering are actually necessary.
So does that become a liability for medical necessity drift, where they start looking at, wow, everybody here is structured based on, their compensation is based on productivity. I wonder what's going on. Let's look a little bit deeper into how they're billing and things like that, supervision and billing and everything, all the other problems that it entails.
So keep in mind that the government or other investigators aren't going to necessarily know how someone is being compensated without doing an investigation. And they're usually not going to start an investigation unless they're seeing evidence of a utilization issue, unless you're delivering, unless you've got non-compliant practices overall where you're getting a whistleblower. But the government's not going around at the beginning saying, give me your compensation plans. However, if you end up flagged for utilization issues, they start doing audits of charts and records, and their audit shows that utilization is enormously high, way outlier, way problematic, trending into the fraud realm. Then in further investigation, they may look at your compensation plan. But truth be told, compensating for productivity is a pretty common practice across the board in healthcare. It's quite common for somebody to be paid a base salary plus a percentage of their collections if they exceed a certain threshold. Well, certainly that person's going to be incentivized to work harder to exceed that threshold. That's fine. If they're an employee, there's nothing wrong with that. And that in itself, it's not a problem. It's whether or not that person trends into delivering unnecessary services that creates, frankly, a different problem. Independent contractors, again, are going to be a little bit different because the safe harbor doesn't say you can pay them anything you want. It doesn't say that. A question came in, aren't RBTs the only clinicians that need to be on W-2 since they need to be supervised by the BCBAs as opposed to BCBAs who can create their own schedule? Creating your own schedule is not the only test for determining whether or not you can be classified as a 1099. There are a lot of clinicians who create their own schedules, but if the employer, just for lack of a better phrase, or company engaging them, is dictating certain protocols, dictating certain other policies and procedures, providing the resources to deliver services, there's a good chance you're also trending for other reasons into needing to be a W-2 at the end of the day. Look, in thinking about whether to classify somebody as a 1099, simply by classifying them as classifying 1099, you're creating a risk just from that. That's just automatically deemed a risk at the end of the day. That's just the way the state departments of labor view it.
How about out-of-network charges combined with routine copay waivers? How frequent is that, and how troubling is that?
It's usually waivers of copays and coinsurance. In this day and age, it's still a lot more frequent than we'd like to see. Let me explain. And by the way, this is usually coming into play when somebody has out-of-network benefits under their plan as opposed to someone who has no out-of-network benefits. This obviously varies by plan, but many plans provide that their out-of-network benefits are that they are going to reimburse a percentage of the charge, right? Let's just take 80% of the charge. Where this becomes an issue is if you waive the copay or the co-insurance share, the insurance plan's view is, okay, that means the actual charge was minus that copay and co-insurance, so I should be actually only covering 80% of what you actually charged. But a lot of times when a provider is waiving copay or co-insurance, the insurance payer is not notified, therefore they believe they overpay, and that's why that is deemed to be fraud. So waiving copays and co-insurance, the issues there have long been settled as being problematic. If that's something you are doing, that is a very high risk practice. It does get found out quite often. And there's very little to defend.
Who's the whistleblower in this case?
Usually it's going to be an employee. I don't want to make people scared of their own employees, but I want you to consider the following themes. Recognize that it's almost always impossible to satisfy every employee. Theme number one. Theme number two. Recognize that the government has done an excellent job publicizing whistleblower processes to the general public and has done an excellent job letting whistleblowers know that if they whistleblow on something, if the government intervenes, if they get something, that the whistleblower is getting a piece of that. Recognize those two themes. They are what they are when you're operating your organization. For better or for worse, the way that payers and the government look at this is you have chosen to enter a privileged sphere by having an ABA practice or any healthcare practice for that matter. And so by choosing that privilege, that comes risk, reward, punishment, whatever you want to call it. And so if you run generally compliant operations, again, we cannot guarantee that nobody will ever make a claim about you. Unfortunately, the way our legal system works is anybody can almost make a claim about anyone else. But if you're running a clean operation, when the investigation starts, it will end pretty quickly because you've got nothing to hide. But the themes are what they are.
At what point does a corporate compliance problem become a personal, criminal, or civil exposure for an owner or an executive?
That's a very good question. There's no real bright line as to when that's crossed to go into that realm. I will say, in some respects, the smaller the organization, the more likely that they will pursue the individuals, because theoretically in a smaller organization, the feeling is that individuals had more control over all aspects of the operation as opposed to a very large organization where individual exposure is less. But it doesn't mean that it's not a risk still in a large organization. There is a very famous or infamous, depending upon what word you'd like to use in the scenario, memo that was written during the Obama administration by a then Assistant U.S. Attorney, Sally Yates, who it was called the Yates memo, that basically put healthcare organizations on notice about executive individual exposure for criminal acts, particularly under the Anti-Kickback statute of their organization. It's really going to depend on facts and circumstances. Usually it's only when the most egregious of processes have been engaged in do you really see that line being crossed.
Let's end on a positive note here. 3 things
is there
ABA
one?
owners...
Have I given many positive notes today?
Yes, you have, but we're going to end on a positive, not a negative. We can pivot to the negative now, but we're going to go positive.
Okay, just making sure.
It's actually been surprisingly positive. 3 things ABA owners should do in the next 30 days to honestly assess their risk.
Number 1 is, and I know people say this all the time, but it does matter. If you don't have a compliance plan, put one in place. If you have one, but it's been collecting dust on the shelves, get it off the shelf, look at it, fix it if it needs to be updated, just do that. And related to that, train your employees on compliance. Now, let me explain why I'm going with that on number 1. If there are problems, if you get investigated, one of the first things the government is usually looking for is, do you actually have a compliance plan? If you don't have one, it's a further black mark. If there are issues the government finds, it's usually going to increase your exposure and increase the penalties simply by not having one. But you got to have one, and you actually have to show you've implemented it. But the reason I also say training is particularly a couple of questions about people who are doing marketing for the organization. They need to understand what is compliant and what is not. The only way they know it, the only way they know how to do that is if you're actually training them on your compliance plan. So that's number 1. Number 2, given some of the themes of this discussion, evaluate your referral relationships. Evaluate whether you think that they are compliant or not, whether they carry some risk or a lot of risk. If you have any questions and you need those relationships evaluated, contact legal counsel. But by what we're doing today, I am a lawyer, but I'm not anybody's lawyer on this call, right? I've given you some of my own views. They represent my views. They don't necessarily represent the views of my 700 lawyer firm. And this technically is not legal advice because none of us have an attorney-client relationship. And I'm not saying you have to contact me. Many of you probably have great attorneys, contact them. But evaluate those relationships. And I'm going to guess many of them are probably fine. Sometimes, and I'm being positive here, so I'm trying to keep the positive theme going here. Many times we do get questions from clients about potential relationships that they're unsure of, and we examine them and we say, no, these are actually fine, and here's why. We don't always find issues. We're not looking to try to find issues. So examine your relationships both on the positive and negative lenses. And the last theme that I'm going to sound off on is reevaluate the status of your W-2s versus 1099s. again, I'm emphasizing the positive aspect of this, which is it's obviously a very entrepreneurial industry we're in nowadays. There's a lot of consolidation in this industry. There's a lot of merger and acquisition. There's a lot of money to be made. Nobody says you can't make money. For-profit providers are just fine in this industry. But if your concept, if your thought process is to roll up your organization for a sale someday, I'm telling you, improperly classified 1099s are a hot issue. I'm not saying it will necessarily derail a deal. It may not, but I have seen it be used to reduce the purchase price sometimes because the buyer thinks they're carrying on an enhanced risk. I have seen it be used to create a special large indemnity pot. I've seen it be used to set aside money for indemnification for many more years than is customary if there were no issues. It will come back to hurt you some way. But I'm twisting this positively by saying if you're looking to monetize your organization and have the big exit someday that most people look to aspire to do, go back and reevaluate those classifications.
Thanks again for joining us, Glenn. That was very enlightening, and I think the listeners enjoyed it as well. And to everyone listening, if this episode was helpful, share it with another ABA operator. The goal here is not fear. It's building clinics that hold up under scrutiny and end up with nice exits. We'll see you next time, and thank you for joining.
Thank you all.